Hey there, Professor Fields here with another lesson in constitutional law. This lesson we're going to talk about the Fourth Amendment and their interpretations from the cases and the perspectives of Olmstead and Katz. Now, the Fourth Amendment, as originally written in the Constitution, said that a search was anytime the police or physical intrusion into a constitutionally protected location, such as persons, houses, papers, or effects. Those are the exact words out of the Constitution. And that worked out great in the first couple hundred years of our country because we didn't have a whole lot of technology, and those were the things that the government was going to search if they were going to search. But in the early part of the 20th century, we started getting a lot of technology, including telephones. And Olmstead was a bootlegger. This is during Prohibition times. He's not supposed to be making booze. He's making booze. He's selling it. And so the police tap his phone from a public street. There's like a junction box in the middle of the street. They go out there, they tap the phone conversations, record or get information from them, and then go get a conviction on Olmstead for bootlegging. It was taken to the Supreme Court, and the Supreme Court said, nope, no intrusion. There was no reasonable expectation of privacy from that public street. Olmstead did not have a reasonable expectation of privacy at that time. So let's fast forward to 1967, Katz versus the United States. Katz was a bookie. That's a person that makes illegal betting. The police put a listening device on the outside of a phone booth in a public place. So you're thinking phone booth, public place, Olmstead, no reasonable expectation of privacy. But it was taken to the Supreme Court and the court ruled otherwise. Their exact words were, the Fourth Amendment protects people, not places. What a person knowingly exposes to the public, even in his own home or office, is not a subject of the Fourth Amendment protections. But when he seeks to preserve his private, even in an area accessible to the public, may be constitutionally protected. So that phone booth conversation, or you walking down the street talking on the cell phone, may be protected by your reasonable expectation of privacy. You have a reasonable expectation that your conversation in those places, especially a closed-up phone booth, is going to be private. On a side note, how many of you millennials have actually made a phone call from a phone booth? Probably not many. They were a mainstay when I was growing up. It used to cost a dime. Then it went up to a quarter. I don't even know if they make phone booths anymore. Maybe in the airport. This, of course, is only the beginning of a series of rulings on when a person has a reasonable expectation of privacy. We're going to talk about this throughout this module. Thanks for listening. Professor Field signing off.